All right, welcome to Senate Judiciary. Today marks an especially good day for Senate Judiciary because we get to consider House bills, which is a lot more fun than considering Senate bills, or at least it can be. With that, let's go ahead and call the roll.
Senator Kriegel.
Here.
Senator Crum.
Here.
Senator Hicks.
Here.
Senator Kolb.
Present.
Chairman Olson.
Here.
You have a quorum.
All right. The first bill for our consideration is House Bill 54, Chancery Court Judges, District and Circuit Court Assistants. This bill is a joint judiciary interim committee bill. Senator Craigo, do you recall this bill?
Vaguely, Mr. Chairman. But I bet there's somebody in the audience who knows exactly what it does.
Ms. Butler, could you walk us through this bill? I was trying to get you off easy, but Senator Craigo didn't bite.
Mr. Chairman, I appreciate the effort. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. What this bill does is it really provides some consistency across the state for judges to essentially pitch in for one another. So right now the way the statutes read, the circuit courts can be assigned to a district court case in certain circumstances. The parties need to agree. The judge needs to agree. And so this just allows for the Chancery Court judge to do the same. And so it provides statutory authority for the Chancery Court to be assigned to district court cases when necessary to help out a fellow judge, and then also to step into a circuit court case as well if needed. So I'm happy to walk you through the bill page by page if you would like, Mr. Chairman, but that's really the gist of what the bill does.
Thank you, Ms. Butler. Do you know what they changed in this bill from the interim
Mr.
bill?
Chairman, the amendments?
Yeah.
Sure, I do. So on page 3, looking at line 4, this was from the House Judiciary Committee. This was some cleanup. The title of that section read Assignment to Circuit Court Judge. And so the House Judiciary Committee just clarified that it said or Chancery Court Judge. So that title now reads Assignment to Circuit Court Judge or Chancery Court Judge. That or Chancery Court Judge language was added to the title. So that was the first amendment. And then on the floor of the House, Mr. Chairman, on page 5, section 2. Previously, this bill would have gone into effect as of July 1st. The amendment on the floor that passed through made it effective immediately upon all acts necessary to make it a law. So those were the two amendments that came out of the House Judiciary and then on the House floor in the other body, Mr. Chairman.
Questions, committee?
Chairman,
Senator Hicks.
so page 4, when we get over to line 13 through the balance of it, this is talking about how we're paying for this, and it says including the judge's traveling expenses, the judge's expenses while holding court. I don't see anything about salary for particularly the retired judges, and then just a little edification on charge to the court where the judge is holding court that's been assigned there, and so obviously that's coming out of existing funds, and so just curious if there was any discussion about, do we see any increased demand associated in certain parts of the state where this is more likely to happen than others? I don't think we're probably going to put a run on that Niobrara County or that district's expenses, but just a little more discussion on that, particularly on the salary for those retired judges.
Ms. Butler?
Mr. Chairman, Senator Hicks, so there are existing budgets. Each of the district courts have their own budget. Each district court judge has its own budget. Each circuit court has its own budget, although that lives under the Supreme Court budget. There is money in each one of those budgets for things like contracting. And so a lot of the retired judges, I believe, comes out of that series. We also have a statewide, it's under the, I can't. anyway, we have a budget. I cannot remember off the top of my head what it's called, but it provides for statewide services. So there is a budget there to pay for things like retired judges to come in and sit if that individual court's budget is insufficient to cover that cost when necessary. So the salaries for retired judges, right now, that sits at what they were, an hourly rate of what they were paid when they retired. So it's basically an hourly rate, however many hours they provide. For those judges who are sitting judges now and who are assigned to cases like in a district court or a circuit court, if it's a chancery court judge, obviously they're not getting any additional salary dollars for that.
Mr. Chairman, just to follow up there, so do you think that language on line 14 through 15, that the judge's expenses while holding court provides enough clarity that that includes salary for retired judges?
Ms. Butler?
Mr. Chairman, Senator Hicks, so this statutory provision 513-116, that wouldn't apply to a retired judge. So that lives currently right within the Chancery Court statute. So that's essentially the authority for the Chancery Court judge to sit in as a district or a circuit court judge. So the retired court, the retired judge authority lives on page 2. So that's in 51106 subsection F. And so that's where we get to how a retired judge is appointed.
All right, thank you.
Senator Kolb, go ahead.
Yeah, thank you, Mr. Chairman. Just a question about this retired judges is, I guess, could you elaborate on just what we're doing here? Because I thought the retirement was at 70 mandated. So is this a way of getting around the retirement mandate at 70? And also the impact on the state retirement fund, if any, for them coming back? And then thirdly, would they stand for retention? How long do you use these said retired judges? Thank you, Mr. Chairman.
Ms. Butler?
Mr. Chairman, Senator Kolb, this is not an end run around the retirement at 70. The purpose of using a retired judge is to have somebody who is experienced at being a judge, being able to come in here and there. They're not hearing a whole docket of cases regularly. This would be a circumstance where we have potentially a judge who is maybe on some kind of medical leave, or something has happened with their family. They need to be away for a period of time, and then the judge will step in. You can also we have a number of cases throughout the state and on some of the district court dockets where there could be a 6-week jury trial scheduled. And so essentially for that judge, what would happen is they'd have to stop everything else that they're doing within that 6-week time frame to hear that jury trial. And so you could have a retired judge who could come in and help out with the docket during that time frame to ensure that that everything stays up to speed, and that when the judge is done with that trial, they're not 6 weeks behind. There is no impact to retirement because any salary that the judges receive, it comes out of the budgets of the courts, or again, that statewide budget. So the retirement system doesn't have to pay that additional cost. And then the third question was retention. The retired judges don't stand for retention. And again, I think the idea behind that is they're not hearing a regular docket. They're not assigned to a court to hear every case that comes out of that. They're hearing a case here or there when we need an experienced judge to step in and help out because of something like an injury or medical leave of a judge.
Senator Kolb?
Yeah, just to follow up. So they are over 70 years old, these retired judges, or not?
Mr. Chairman, Senator Kolb, they could be, but not all judges stay until they're 70. And so they could have retired prior to 70. It just depends. The other thing to keep in mind is neither the circuit court judges nor the chancery court judges have a mandatory retirement at 70. It's the district court judges and Supreme Court justices who have that mandatory retirement age.
Going back to page 4, subsection C. Subsection C applies expenses, or pertains to expenses both incurred in the circuit court and the district court. Is that correct? It's not just circuit court.
Mr. Chairman, so it would apply when, in the circumstances that a Chancery Court judge, correct, that a Chancery Court judge is assigned a case either in the circuit or in the district. And it just clarifies that if the Chancery Court judge is sitting in either one of those courts, that court's budget is going to cover the costs.
The reason why I'm asking is because the title to the statute says expenses of judges when acting in a circuit court. So it should say when acting in a circuit court or a district court.
Mr. Chairman, I believe you are
Those
correct.
House members missed that. How could they? Okay. Other questions for Ms. Butler? What was the logic behind making it effective immediately?
Mr. Chairman, I don't know the answer to that. That was brought by an individual representative.
Okay,
I can venture a guess.
because we want it effective immediately?
Mr.
Senator Craigo?
Mr. Chairman, because we have a Chancery Court judge now who probably could actually be utilized to be doing some of this stuff if necessary, rather than wait 4 or 5 months.
Does it remind me how it works in the reverse? I'm just curious, not, this bill doesn't address this, but if the Chancery Court creates a temporary vacancy that needs filled for vacation or whatever it may be, are those just district court judges, or can circuit court judges fill in as well?
Mr. Chairman, I believe the way the statute reads now, it's just a district court judge who can fill in. Prior to the time that we had a full-time Chancery Court judge, it was district court judges who took on that task. So yes, I believe, I'm nearly certain it's just the district court judges who can perform that task in Chancery Court.
Okay. All right, any other questions for Ms. Butler? Thank you, Ms. Butler. Any public testimony on this bill? Welcome.
Thank you, Mr. Chairman. Joey Correnti. I'm going to testify as a private citizen today. I have a lot of intimate knowledge and a lot of experience in the court, so another one that caught my attention, and you beat me to the punch. A catch title doesn't match some of the provisions within the bill, and I don't know which way the committee or the body would want to address that, but there are parts within the body of the bill, specifically which level of court going either way, whether someone's coming from a higher court down, but most concerning a retired judge sitting in a district court position or higher, that would either need to clarify the language that it has to only be circuit or chancery court because of the retirement mandate already in law, or something in the bill, an amendment saying temporarily suspending for the assignment if it's going to be district court, just to clean up the language. I know if I look at something and have questions, there's a lot smarter people than me, especially on the judicial side of the state, that might look at it and say, this isn't totally clear. So I think it's a good idea, just a little tune up, and stand for any questions.
Questions for Mr. Correnti? All right, thank you. Other public testimony? Is there any public testimony online? Not for this bill. All right, I will close public testimony. Committee, what is your pleasure?
Move the bill.
Been moved by Senator Craigo. I would offer that amendment on page 4 to line 3 to include or in a district court. I don't know if that's the best way to write it, with an or. I don't really know how they write these statute titles. Probably doesn't matter a whole lot, but it's nice to clean up a House bill. Discussion on this amendment? Nope.
No, I'm in favor of the amendment.
All right, all those in favor signify by saying aye.
Aye.
Any opposed? Okay, Senator Crum?
Yes, I'm wondering, listen to Mr. Craney, if we should put something in this bill that says there's no mandatory retirement age for a judge or something like that.
Senator Craigo?
So, Mr. Chairman, thank you, Senator Crum. That's actually constitutional. And we tried that a couple years ago, and that did not go anywhere, actually. And so it is mandatory, but I will tell you that that is a procedure that is not used a lot, but when it is used, it's already in statute. So we're not changing that. All we're saying is that if you happen to be a retired Chancery Court judge, you can be assigned to a case. So we're not changing that. We're not adding anything to it other than to say that a retired Chancery Court judge gets treated the same as any other retired judge and can be asked to serve on assignment now and again, which I don't know how often it happens, but I know even in our jurisdiction, we have a retired judge that is from the community, and every once in a while he fills in when the district court judge is sick or wants to go on family vacation. I mean, it's literally, that's how often it happens, not very, and it's nice to have someone who can do that. So I'd urge any efforts to change that statute because it does come in handy for our judges, and it's not used very often.
Well, can you insert it here?
What's that, Mr. Chairman?
You said you would invite any opportunity to change that statute.
I would urge against any change.
Oh, against.
Yes.
Oh, okay.
Sorry, if I said that, I stand corrected. I said I would urge any efforts to change the statute because it does help especially in the smaller jurisdictions where we don't have 3 or 4 judges in one town. We have one judge in town.
Senator Kolb?
Thank you, Mr. Chairman. Who determines when this happens? When it comes to replacements or exchanges for filling in for judges. Is it the Supreme Court have anything to do with it, or is it not? It's a general question.
Do you know, Senator Craig?
Mr. Chairman, I don't know the exact procedure. I believe it does run through the Supreme Court, through the office down here, but I know Ms. Butler would know the answer to that.
Ms. Butler? We're just curious on what the process looks like. I imagine it would be different for a circuit court because the circuit court's not under the Supreme Court. Oh, it's the other way around. The district court isn't under the Supreme Court.
Mr. Chairman, Senator Kolb, so what happens now is if a judge is in need of a retired judge to come in and fill for a case or a certain amount of time is the judge will make that request of the Chief Justice, and the Chief Justice generally consults with an executive committee of the Judicial Council, which is made up of a district court judge, a circuit court judge, and the Chief Justice. And then they make a decision on whether or not that judge should step in, and then the Chief Justice enters an order that allows for the retired judge to step in for the judge who is in need.
That's true for district court judges too?
Mr. Chairman, yes.
Interesting. Okay. Any follow-up?
I do have a follow-up.
Go ahead.
The percent of utilization of the Chancellery Court has always been a question in my mind, so it seems like a good thing, your opinion now, that we utilize the Chancellery Court judges when we can, when they're not busy. And I don't know what the workload currently is, but it wasn't very high when it first started in Chancellery Court. So the question is that why we want to do this? Thank you, Mr. Chairman.
Ms. Butler?
Mr. Chairman, Senator Kolb, I think in part, yes, absolutely. We want to make sure that all of our judges are working fully. They're getting a salary, and so they should be fully employed while they earn that salary. And by and large, I would say they are. But absolutely, if the Chancery Court judge has space, it makes sense for them to be able to pitch in other places.
Anything else? All right, thanks for coming back. Any other amendments on this bill? Or discussion? No? Okay. Let's do a roll call vote on House Bill 54.
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks left an absentee vote of aye. Senator Kolb,
Aye.
Chairman Olson.
Aye.
5 ayes, do pass amended.
All right. Thank you. Let's go to our next House Bill 189. harmful communication minors. Welcome to Senate Judiciary.
Mr. Chairman, members of the committee, my name is Representative Jamie Lean, and I'm from House District 38. Today I bring to you harmful communications with minors, House Bill 189. I have a few statistics for you to get started. 774 children were served forensic interviews. 306 of those were sexual abuse cases. Among them, the parent was 138 times the abuser. The offender was 45 times the step-parent. 79% of those were relatives, 79 of them were relatives to the victim. 94 of them were the parent's boyfriend or girlfriend, and 73 of them were unrelated to the person and the victim known. This is just within the state of Wyoming. When an adult involves any child in a sexual act, including fondling, exhibitism, voyeurism, exposure to pornography, internet chatting around sexual topics, the statistics become shocking. 1 in 4 girls are sexually abused before the age of 18. 1 in 6 boys is sexually abused before the age of 18. 1 in 5 children receive sexual solicitation while on the internet. 39 million survivors of childhood sexual abuse reside in the U.S. Children are at a higher risk than adults for sexual victimization. More than 67% of all sexual assault victims are under the age of 18. The median age is 9 years old. Family members only account for 40% of these. 50% of the time it is acquaintances. Those could be the child of a friend, a neighbor, a student, sport participant, a babysitter, things of the like. More than 80% of sexual abuse cases happen in one-on-one adult-child situations. I have before you today House Bill 189, and I'll walk you through it. We're going to create a new section of law starting on page 1. This is created to read sexual communication with minors, penalties, civil cause of action, and social media prohibition. As you walk through page 2 and 3, there are definitions. They walk through what is obscene, and they walk through behaviorals intended, attempts to normalize sexual contact, behaviors intended to desensitize minors for sexual content, inappropriate for the minor's age, and then there's a list of what that's based on so that the law enforcement has an opportunity to see if this was relevant to the maturity of the child. On page 3, line 12, it talks about a pattern of communication. Yes, this bar is set low because two times, that would be 2 different children that would have potential to be harmed, and that is too many. It further goes on to define sexual personal gratification and what that all entails through page 4. As we move on to page 4, line 12, it talks about how you, in this section, it talks about that you are knowingly engaging in a pattern of written, electronic, or verbal communication. The next section talks about a person that is less than the age of 18 or a person that is purported to be less than the age of 18, because there are sting operations that happen that do draw in individuals. On page 5, it walks us through if the actor is more than 4 years older than the victim, that the communication includes obscene verbal, written depictions, or obscene images. Line 8, when the actor engages in a pattern of communication for the purpose of personal sexual gratification, that is when this shall be applied. And then from there, we move on to offenses and how they should be punished. They're punished based on a tier scale for those repeat offenders. For you see, the first offense will be 1 too many, but we understand that we're all human and sometimes we make mistakes. So that first time would be up to 5 years in jail and a fine not less than $1,000, up to $5,000. And the second offense would
Can I ask you, sorry, you just said 5 years in jail?
prison,
Oh,
sorry.
Okay, I wasn't sure if there was some nuance there that I was just missing.
I'm sorry, prison, I misspoke.
Okay, thank you.
And then the second offense would be 10 years, $10,000. And then the third offense would be up to 20 years or $20,000. I did find an amendment that needs to happen within those three tiered sections. It says and, so in the House, we amended this to say or both, but the cleanup language got missed. On line 16, it says 5 years and, it should be a comma and strike the word and. And then again on line 21 of page 5, and then at the top of page 6, line 3, strike the and put in a comma so that all three offenses, the judge has the discretion to issue what is best for that case. As we continue through the bill, persons convicted under this section, they may be prohibited from losing social media privileges while they're in incarceration, probation, or on parole. Further down, it says they shall be subject to forfeit the devices that they were used to communicate with the minors or the purported minors for the evidence-based purposes that they could apprehend that right away. And as long as we keep moving through sections 6 and 7, or pages 6 and 7, we have that you could bring a civil suit and that it is not subject to the criminal conviction. In section G on page 7, line 5, you'll find that this shall not apply to persons that communicate or instruct about sexual matters in the course of age-appropriate sex education, curriculum, or program at any church, school, college, or university. We want to make sure that we're not inhibiting our individuals from being able to learn to be nurses, or that those children that are going through puberty in the public education system do have proper education about the changes happening within their body. As we continue to move through there, section H, this section allows for a minor to come forward if a parent is the abuser. That way, law enforcement has the ability to talk to that individual prior to contacting the parent. Section J, this section shall not apply to minors or their spouse if they are married, and that is on record from a judge, or that a minor's parents or legal guardian have approved for consent of a minor, because legal age to marry in Wyoming is 16, or if the minor is emancipated. So there are a few exceptions to this law. Finally, on page 8, we walk through amending statute 719-302 to include 62321 that we're creating here today, that these individuals that are sexually chasing our children will then register as a sex offender within the list. The enactment date on this is effective immediately, so that those sting cases that are already being operated or individuals that are being followed that law enforcement cannot currently prosecute now have the opportunity to move forward with that investigation, because we're all aware that that takes time and we'd like to take care of our youth. In conclusion, this bill closes a hole in law where sexual communications leading up to the sexual abuse with a minor are currently not being addressed. If we as lawmakers can give the legal system the ability to stop the grooming of our children, in turn, we will see a healthier community and a stronger health in our youth. And with that, I'm open to any questions.
Questions for the representative? Senator Cole.
Yeah, thank you, Mr. Chairman. Representative, I guess, was this model language from another state? I just wondered where this came from, this, when you came up with this. I mean, how did you get it? How did this come to be, I guess?
Representative Lee.
Thank you, Mr. Chairman and Senator Kolb. This is just language that I had read in several other states and compiled together from multiple states. It's not one individual state's language. The bulk of it is just my own thoughts and words that went into it.
Yeah, Senator Cole.
Thank you, Mr. Chairman. It would look like you might have the unintended consequences of forcing marriages for underage people, because that's exactly what somebody would do under this circumstance. They would, if possible, go off and get married, and to stop any action from being taken against them. And I just wondered what you thought about that, and or just what your thoughts were. Thank you, Mr. Chairman.
Representative Lee.
Thank you, Mr. Chairman and Senator Kolb. I had not given that any thought. My suggestion would be that on page 8, line 8, where we add in section 62321, that you make that specific to this section of the third conviction. So that would be this statute, section C, Romanet III, So then it would be only upon the third conviction of grooming children would they have to then register as an offender. Would that take care of the ability to say, we're going to force childhood marriages based on?
Senator Cole?
Thank you, Mr. Chairman. Oh, at the first sign of an issue, if that was the case of this inappropriate contact, they would, the first thing you'd do to shield yourself was to go get married. So no, I don't think that gets to the issue. That was my concern when I was reading it, that you could have an unintended consequence of that happening, which is what happens when we try to write law, some things. So that was my question, just what you thought about that, and if there was a way, or I guess you did answer it, so thank you for your answer. Thank you, Mr. Chairman.
Yes. Other questions for the representative? Senator Craigo.
Thank you, Mr. Chairman, Representative, good to see you. So I'm envisioning a circumstance where we have a young couple, it might be in here, this is why I'm asking the question. One of them is 17 years and almost, 1 day short of being 18, and one of them's 18 years plus 1 day. And they engage in this type of communication. Is that a crime under this?
Representative Wing.
Mr. Chairman and Senator Craigo, thank you. That is not a crime under here. We do have a 4-year age gap that is listed out for you. On page 5 at the top in this in Romanet 2, that the actor is more than 4 years older than the victim. So in this instance, if the individual is 17, they would have to be greater than 4 years older than them. We do not want to inhibit the natural cause of individuals that are 16, 17, 20 years old that engage in very normal relationships. The intent is not to condemn or to charge any of those individuals, hence the 4-year age gap. That this is merely for those individuals that are older and seeking very much younger children.
Yeah, I suppose it's just the question of where you draw the line. In Senator Craigo's example, it could be the 17-year-old with a few days left until he or she turns 18, and then a 4-year-old. Have you given thought to that? Or why did you pick 4 years, I guess, is the question.
Thank you, Mr. Chairman. After careful consideration and reading other state laws, 4 years seem like an appropriate age matter, given the maturity of some individuals, that some young women will mature quicker than young men or before young women. And so 4 years seem to be an average across state law in other states, that it was the ability to remain within the maturity levels of each other to have normal and natural consequences within those relationships.
How did you come up with the tiered punishment section? Why did you choose 5 years, then 10 years, et cetera?
Chairman Olson, thank you for that. The intent of it is, we understand that sometimes people make mistakes, and so the first time you may not need as harsh of a penalty to get the point across. And the second time, you're gonna need a little more infraction there so that you get their attention and you let them know. By the third time, this has become a habitual pattern, and we want to make sure that we're letting them know that this is unacceptable because these are our youth. The tiered system is just something that comes from many sections of law, that the first time you're an offender for many different things can end up being a variety of penalties. And so this was just one way that we offer the judicial system the ability to take all of the circumstances surrounding the case into consideration to issue a penalty.
Senator Cole?
Thank you, Mr. Yeah, just getting, thank you. Just getting back to the penalties. You don't often see this type of tiered penalty that you've got laid out here. And on the third and subsequent offense, I mean, how old are you? I mean, add up the numbers here. 5, 10, 20. So I don't understand that. I mean, I get the first offense, the second offense, it's usually a misdemeanor actually, right? Then it's a felony. We step up to felonies. Felony, felony, felony. if it's another person, I suppose, people are getting pretty old by now. I just wondered what the real need is for the third one. I'm confused about why that is necessary. Under what circumstance? I mean, why is it appropriate here and nowhere else, I suppose? And just why did you have these numbers? I mean, the amount of time incarcerated, the amount of fine, which is gonna be amazing. I don't know how you're gonna make any money. I mean, you're gonna be in and out of jail, I suppose, so I don't know how you're gonna get the money out of them, but just a reason for the third one. I mean, what logic was used to come up with that? Thank you, Mr. Chairman.
Representative Lean?
Mr. Chairman, Senator Kolb, the reasoning behind it is that the judge will have the ability to choose. So just because there's a 5, 10, and 20-year imposition doesn't mean that they're going to, in fact, serve that time. Maybe say on the first time he gets 60 days, maybe on the next time he ends up with 2 years. And so the third time just speaks very clearly that you're not allowed to harm a student or a young adult, a minor, in this case. When it comes to the health and safety of our youth, I don't believe that these are sound enough. I believe that they need to be even bigger.
Senator Craigo?
Thank you, Mr. Chairman. So tell us how to define purported minor.
Senator Lean, or Representative Lean?
Mr. Chairman, Senator Craigo, a purported minor is just somebody that is in a sting operation, and if I could invite Victim Services up, she might be able to answer that question for you better. Somebody that's pretending to be a minor or pretending to, in order to have the individual respond to them with, let me gather my thoughts, I'm sorry. So a purported minor would be somebody that is intentionally not a minor, but pretending to be a minor for the intention of drawing together a criminal. And Victim Services is here from the agency if you'd like to. I could defer to her if you'd allow her to come to a microphone.
We can just save that question for her
Okay.
when we get there. Senator Crum?
Yes, Mr. Chairman, kind of just trying to clarify here, couple words, obscene and gratification. What do those words, I have my opinion of what those words mean, but what do they mean in the law? Are they defined somewhere?
Representative Lean?
Mr. Chairman, Senator Crum, so if you'll turn to page 2, obscene, and then it says means the communication that includes any of the following when directed at a minor or purported minor. And so every one of these steps, explicit descriptions of sexual contact, descriptions of sexual arousal, requests for sexual images or sexual discussions, sexualized descriptions of human bodies or human parts, attempts to normalize sexual contact between adults and minors, and behaviors intended to desensitize minors to sexual contact inappropriate for the minor's age. And then there goes to another section where it talks about their developmental stage, the lack of parental consent, the context of the communication, and that it's an ongoing pattern. So that would be the new amended version from what is in our current statute.
Okay, thank you. And then what about gratification, Mr. Chairman?
Representative Lean?
Mr. Chairman, Senator Crum, thank you for the follow-up.
Page 3, line 21.
Yep, page 3, line 21, personal sexual gratification means, and then it carries over to page 2, the arousal and appeal of sexual desires to obtain sexual arousal or pleasure, elicit sexual response or reactions, create or share sexual explicit content, engage in sexual explicit role play.
Got it. Thank you.
Senator Craigo?
And so maybe this goes back to the 4-year provision, top of page 5. It says except as provided in subsection H, except as provided by subsection H, and I'm wondering if that should be G. I'm not sure. I'm trying to track in whether it actually lines up with H, and I think it lines up with G, which is the school an educational provision, because it's a carve out.
Representative Lean?
Thank you, Mr. Chairman and Senator Crago. This portion came in from an amendment, and I was just looking at the non-engrossed version. And I don't see a section H in the non-engrossed version. In this version, it is section C, or G, sorry.
Okay, any other questions for the representative? All right. Thank you. We'll move to our agency's testimony. Police, we have at least one question for you. You don't have to testify, but
Thank you, Chairman. Kara Chambers, Attorney General's Office, Division of Victim Services. Yes, just stand for any questions and clarifications if needed.
Senator Craig, you had a question. I don't remember what it was, though.
Well, I don't.
I-
Mr. Chairman, I do remember my latest question, which is whether
Okay.
it should be H or G.
Chairman Olson, Senator Craig, it should be G, and that was an oversight amongst the amendments.
All right. Do you remember the other one now?
No, but I
Oh,
have
you got a new one. Okay. Go ahead, Senator Craig.
So just a question, and how this would kind of line up, Ms. Chambers, with our, sexual assault of a minor. We have various age limits, and it gets really complicated, and you're one of the few people I know that actually knows it. So how does this particular, the language within this bill line up with those series of statutes?
Ms. Chambers?
Chairman Olson, Senator Crago, specifically to your question about the 4-year age difference, you do see that in other sections. And you're right, it is convoluted, and our statutes have varying degrees, but I think the 4-year was an attempt to mirror language we have elsewhere. I couldn't cite the exact statute. I've never been the attorney who could do that.
Senator Kolb?
Yeah, thank you, Mr. Chairman. I haven't asked this question before, bills, but do you believe this bill improves what we're doing in the state of Wyoming? Is this an improvement or not? Or just what your opinion is? I don't have a chance to review it yet, but I'd just like to know what you think of this bill and what it's trying to do. Thank you, Mr. Chairman.
Ms. Chambers?
Chairman Olson, Senator Kolb, that's always a tricky position for an agency. What I can say is that this bill captures some activity that we do see happening with child victims where they are groomed. I think Division of Criminal Investigations, Internet Crimes Against Children Unit would say that they see this sort of activity as a precursor to some other crimes. I can see where this would be helpful, but it's a policy decision for your body.
Just to follow up on that, Ms. Chambers, what does the average age of the child look like who's being groomed?
Chairman Olson, I don't have that right in front of me, but unfortunately, I've seen as young as 6, and I think the average age is about the age when they start to get cell phones, which gets younger and younger. We do seem to have that wheelhouse of 13 to 16, in my opinion, but that's purely anecdotal.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Just to follow up on what I had asked. So more to the point, do you have mechanisms currently that you can use that would do what this bill is talking about doing? Can you do these same things without this bill, I suppose, is my question. Thank you, Mr. Chairman.
Ms. Chambers?
Chairman Olson, Senator Kolb, it depends. I know that's not the answer you want to hear. It depends. I don't think there's any harm in expanding and clarifying some of the things that are in the statute. But again, I really have to be careful and just say that this is a policy decision for you. It doesn't hurt.
Senator Crum?
Yes. Ms. Chambers, or Mr. Chairman, question for Ms. Chambers would be, the penalties that are here, that 5, 10, 20, is that kind of standard, like the 4 years is kind of a standard thing? Is that, would that be standard or outside of standard?
Ms. Chambers?
Chairman Olson, Senator Crum, that does mirror some of the penalties that we see in other provisions of sexual assault. But again, it is all over the place. But, you know, that's a policy decision for the body. But it's not unusual where we start with the tiered.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Page 7, line 15, and where it goes on to say law enforcement believes the parent or guardian will interfere with the investigation. Is that language that we see in other places? I mean, does that give a buffer enough that, I don't know what the mechanisms are that you would go through in order to make this determination about a parent? I mean, is it going to be jurisdictional up to whoever is the investigator? Just your thoughts about that sentence. Thank you.
Ms. Chambers?
Chairman Olson, Senator Kolb, you know, I will also defer to law enforcement in the room. I will candidly say that I wasn't clear why that needed to be in here, because I think we currently investigate parental, incest cases, and so I don't know that that was necessarily needed. I don't think it does any harm. I think that happens. Law enforcement have to come in and investigate suspected child abuse, no matter who the perpetrator is. And I can see a situation where a parent, the offending parent might try to interfere, but I believe we have ability to work around that already. This was additional language that came in after the original bill, for the record.
Any other questions for Ms. Chambers? All right, thank you. Mr. Thompson? Were you going to testify on this bill?
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. To answer that specific question that was just discussed, I would echo the testimony that it's not necessarily needed, but I think it does cover an instance where, in my experience, when we're dealing with people under the age of 18, these cases like this come to light in a school environment. And many schools have a policy requiring notification of parents, and to have it explicitly listed in statute there, which is already a practice that law enforcement isn't required to notify a parent in cases where they think that that will interfere with the investigation or the parent is a suspect. I think this language does cover anything that might arise in these types of investigations and put law enforcement in a favorable position to investigate it fully. And sorry, Mr. Chairman, and I would just also like to indicate that we've been heavily consulted about this bill. We've had a lot of our members look over it, and there's widespread support for this concept. We do think it does. I don't know if it's necessarily a hole in the statute, but I think that there is a lack of applicability of existing law to what we commonly refer to as sexting, which is often the first step in grooming someone for later sexual assault. And we do believe that if we can interfere with that grooming process at an early stage like this, we can prevent further victimization of those children.
Questions? Senator Crago?
Sorry, Mr. Chairman, I'm going back to this because this is the only part about the whole thing that I'm having a little uneasiness about is there a place where this particular law would have more ramifications or more serious penalties than where based on the age difference, right? Because this is why I asked Ms. Chambers this question as well, is I'm thinking there's the math gets really complicated, right? And so you're dealing with a 17-year-old young lady and a 21-and-a-half-year-old young man. It's over 4 years, but I don't think that's a crime. I can't remember for sure. That's why I'm asking that question. It would be a crime here, but you could actually have, they could be having sexual relations and it's not a crime, but it would be a crime if they took a picture of themselves. And so that's what I'm trying to make sure we're threading the needle in the right spot and not creating unintended consequences. And so that's why I keep asking these questions, because I think that's correct, but I'm not positive. So I could use some help on that, Mr. Thompson.
Mr. Thompson?
Yeah, Mr. Chairman, I don't have the statutes in front of me, and I'm looking for them on the sharing of explicit images. But we have changed that to juvenile sharing with juveniles being a different level than adults sharing with the juvenile. And there is, I'd have to look it up, but the age difference is very common language that when they're younger, 12, 13 years, then we're looking at 3-year age differences. As they get older, that's expanded to 4-year age differences. And you know, so we have sexual assault of a minor in the 4th degree being that 4-year age limit, and that encapsulates those 16 and 17-year-olds, but it talks about a position of authority, right? So yes, I think that you could have a 16-year-old that's legally dating a 23-year-old they're engaged in sexual intercourse, and it would otherwise not be prohibited by law. But this would, but I also think that sharing of images, especially if that 22-year-old had an image of the 16-year-old, even if they're legally together, that's still a violation of law if that 23-year-old is possessing an image of that 16-year-old.
Unless they're married.
That's what I was saying.
Other questions for Mr. Thompson? I am remembering now when we did the statutory work on sexting that we had a complete carve out for juveniles. It was an entirely different way that we approached it. But has that been discussed at all with this bill or?
Yeah, Mr. Chairman, I hadn't, because I'm under I have to look at the statutes again, but it's my understanding that 2 juveniles engaged in that activity, while still a violation of law, because we don't want images of people under the age of 18 existing to begin with, that would be a misdemeanor crime, as opposed to an adult involved in that situation over the age of 18. Then it becomes a felony, and it falls into the ICAC-related laws that we have, and I'm struggling right now to find them quickly up here in front of you.
Okay. Other questions for Mr. Thompson? All right, thank you.
Thank you, Mr. Chairman.
Other testimony, please come forward. Mr. Carenti?
Thank you, Mr. Chairman. Joey Careni, Carbon County. I am a survivor of pre-adolescent sexual assault by a family friend. And again, this is something that's pretty important to me. I've heard a lot of questions from the committee. I don't know that I have answers because they're all about the legal ramifications comparative to other crimes, how many years is appropriate. Does this stuff happen on cell phones? My situation happened before cell phones, before social media. It's an old problem. What I'd like to focus on is 2 things that no matter how this sausage ends up getting made by the committee or the body, that these definitions remain, maybe get clarified a little, but the ability for the family or the victim to engage in the civil litigation remains. Because there's many situations, whether it be Fourth Amendment, Fifth Amendment, a pandemic where people just aren't getting prosecuted anymore, lack of abundant evidence, lack of, initial reporting, that there should still be a route for people to be able to participate in their own justice, especially when it comes to their child. These things have long-lasting and deep impacts, and the reason I think that this is so important, it gives them the opportunity to engage at the initiating level that turns into these other things we may already have laws on that might cause some of the language in this proposal to be duplicative, or the initiating action having a harsher penalty than some of the other things we're seeing. So again, that goes back to the sausage being made, but really I would like to focus on retaining some of these definitions and making sure that the person's ability, the family's ability, the victim's ability to engage in that when, I'm not going to say law enforcement or the courts fail us, but things happen. Sometimes it just doesn't get pushed through. But to be able to engage in your own justice, especially on behalf of your child, and I think we're all parents here, it's a big step. It allows you to take that big step on the first step before these other things do happen. And it does avoid that frustration. The system's failed me. This guy's getting away with whatever he's doing to my kid. And then it leads into other laws that have very harsh penalties here in Wyoming. So with that, Mr. Chairman, I'll stand for any questions.
Questions for Mr. Correnti? All right, thank you. Appreciate your testimony. You're up.
Thank you, Mr. Chairman. Dr. Ben Moritz, I'm Executive Director of the Community College Commission. We have identified one area where there could be unintended consequences from this bill. We have a suggestion for perhaps how that could be addressed. I'm citing Section G, that carve-out that you mentioned. There are programs at the colleges as well as the university, specifically human services, criminal justice, which are intended to help train those who could stop and prevent these types of either sexual abuse or sexual predators. Part of the training that goes into that is instruction as to what this looks like, what examples of this type of thing. And there are occasionally minors in colleges and the university. You don't have to be 18, you can be 17. And so we would like a perhaps expanded carve out in G. We have some different examples of language that could be appropriate if the committee is interested. As it states right now, there could be an unintended instruction, including some of the obscene, some material that is obscene as defined earlier on, provided to a minor who it was not known or it was not intended for that purpose.
Mr. Moritz, do you have any of those amendments with you in writing, or
I've just,
are they just simple?
they are simple. I've just
Okay,
written
go
them
ahead.
down. I
Yeah.
could, okay. In item G, or paragraph G, after school, college, or university, you could add, including human services, criminal justice, or related academic programs intended to protect minors from social abuse or predators.
Oh, I see, because your hangup is on the language sex education curriculum, that it may be for some other purpose.
Mr. Chairman, yes, exactly. Colleges and university don't typically teach sex education curriculum. I think perhaps this was intended to cover, it may have been intended to cover exactly what I'm describing, but as it's written now, it refers to a very different type of curriculum.
Okay, can you give that to us one more time?
Mr. Chairman, yes. Adding human services, criminal justice, or other related academic programs intended to protect minors from sexual abuse or predators.
So can we just say including any academic program? We don't have to say criminal justice or human, what was it, human resources?
Mr. Chairman, it was human services.
Human
but-
services.
But I agree. The names of programs can change from time to time. I had been more specific just because I wanted to be sensitive to the fact that this is a serious problem, and the colleges are definitely not opposed to anything that can address that. But academic programs related to the protection of minors, something like that, would be probably more effective given the fact that program names do change.
Okay, got it. Any questions for Mr. Moritz? All right, thank you for your testimony.
Mr. Chairman, members of the committee. My name is Erin Taylor. I represent the Wyoming Association of Community College Trustees. Since I communicated with you via email and I've worked with the sponsor, I just wanted to stand up and let you know that what you heard from Dr. Moritz is the position of the colleges. However, it makes it understood and, not getting in the way of the intent of the bill. We definitely would support that. I usually like to not have lists of everything, like for the reasons you heard from Dr. Moritz, but however the committee deems it appropriate, I think would be good with us.
Questions for Ms. Taylor? All right, thank you. Any other public testimony? Testimony online? Ms. McCoy? Maybe? Okay. Welcome.
Thank you, Chairman. My apologies. My computer runs a little slow today, apparently. My name is Patricia McCoy, and I am here today to speak in support of House Bill 189, which addresses harmful sexual communication with minors. As a parent myself, I've seen firsthand how predators use modern technology to target and harm our children. This bill fills critical gaps in our current laws by addressing not just the direct sexual abuse, but also the grooming behaviors that often precede it. Some may worry about overreach, but this bill carefully targets predatory behavior by requiring clear patterns of exploitation, not isolated communications. The carefully crafted definitions ensure we're stopping predators while protecting legitimate speech and education. The civil cause of action is a crucial component of this bill. Many families I've spoken with have found that criminal prosecution isn't always possible or sufficient. Giving minors and their parents the ability to seek civil remedies independent of criminal proceedings provides another vital avenue for justice and accountability. I understand concerns about enforcement challenges, but this bill provides practical solutions. The graduated penalties and requirement to prove intentional repeated behavior ensure we're targeting actual predators, including purported minors, closes a common loophole that predators have long exploited to escape justice. Some question whether social media restrictions are too broad, but the reality is that modern predators rely heavily on technology platforms to access and groom children. The bill's approach is measured. Restrictions only apply after conviction and during probation or parole, targeting proven offenders while they pose the greatest risk to our children. The bill also allows remarkable insight in its provisions protecting minors who need to report abuse without parental notification, particularly in cases where a parent might be involved or might interfere with an investigation. This demonstrates that this legislation's primary focus is protecting children in all circumstances. This carefully crafted legislation strikes the right balance between protecting children and preserving constitutional rights. We have a responsibility to give law enforcement and families the tools they need to keep our children safe in an increasingly connected world. The predators targeting our children aren't waiting. They're actively exploiting every delay and hesitation in our laws. We have a moral obligation to act swiftly and decisively to protect Wyoming's children, and I urge you to support House Bill 189. I thank you for your time and will answer any questions.
Any questions for Ms. McCoy? All right, thank you.
Thank you.
Any other public testimony online? Okay, I will close public testimony. Committee, what is your pleasure?
I'll move the bill for discussion.
Okay, Senator Craigo moves the bill. Amendments to this bill, this first amendment, I did receive this from LSO, the one that was presented to us by the sponsor. Okay. Amendment 1 to House Bill 189 has been moved. Any discussion on this amendment? All those in favor signify by saying aye.
Aye.
Adopted. You got that, Pierre? That was the written one?
Page 5, Mr. Chairman,
Oh, okay.
line 1, H should be G.
Okay.
I would move that amendment, Mr. Chairman.
Any discussion on this amendment? All those in favor signify by saying aye.
Aye.
Any opposed? All right, that amendment has been adopted. Senator Craigo, I had a question about, on page 3, there's a definition of personal sexual gratification. And it says it means communication intended to, and then it provides a list. There's no or between D and E. I think it needs an or. Is that, no, wouldn't you
I would
agree?
agree.
Okay.
So line 8,
So yeah, line 8, insert or.
so moved.
Okay, any discussion? All those in favor signify by saying aye. Any opposed? All right. Any other amendments? Senator Kolb?
On page 6, lines 1 to 4, under Romanet 3, strip that out. So that removes the third or subsequent offense as a felony punishable by imprisonment not more than 20 years and a fine of not more than $20,000 or both.
Okay, you're deleting the Romanet 3.
Yes.
Okay. Discussion on this amendment? All right, all those in favor signify by saying aye.
Aye.
Any opposed? Okay, that amendment does carry. And it looks like, yeah, the language is sufficient between 1 and 2. So I guess it would, you could probably get this in cleanup, Pierre, but it would go, the amendment would include page 5, line 22, strike or both at the end of the sentence.
No.
No?
No.
Yeah, it'd be a period. Well, it's the end of the, there's only a first and second offense now. There's no third offense.
Right, but they all end up with or both.
Oh, the or both applies to the,
Fine or
the fine or the, yeah,
Imprisonment.
yep. But there would be a period.
Yeah.
That's true.
Okay. Any other amendments?
A question, Mr. Chairman, on line 15, same page, page 5, where it says felony. You know, we talked a lot about the person being 4 years and 4 years and a half and having all these. Is there a way to insert with the judge's discretion misdemeanor? You know, it can be a first offense, maybe a misdemeanor or a felony punishable by up to 5 years. And then
I don't
I'm
think so.
seeing no on that.
I don't think so.
Okay.
You could make it a misdemeanor. You could make the first offense a misdemeanor, but you'd have to pick between one and the
You
one and the
can't
other.
let the judge decide that.
I don't think so.
Yeah, I mean, I don't condone this activity, don't get me wrong in any way, it's just,
Make the amendment that we make it a misdemeanor, change the amount of imprisonment and the fine, if that's possible.
And have the second offense be the felony?
Be a felony, but the second, I see that more often as that. First offense, a misdemeanor, second offense.
I'd make that a motion then.
So you want, your motion is to make it a misdemeanor, 1 year, right?
Mm-hmm.
Up to $1,000,
Yeah, whatever, yes.
and then strike the rest of the sentence on 17 and 18. Does that make sense, Pierre? Up to $1,000. Yes. Okay, discussion, Senator Craigo?
On and against the amendment, Mr. Chairman. I actually don't even like the stair stepped. I think I'd be happier if we just had one, you know, it's a felony, period. Because what we're trying to get at is if this is a crime and we're talking about someone who's 22 and they're sending these messages to someone that's 14 or 15, that should be a felony. Whether it's the first time or the 10th time, that should be a felony. And so I'm not, you know, I understand if we want to create, as we don't have time today, we can,
Create a whole
if we want to create a whole carve out, and this is why I brought up the discussion about these other crimes that we have, it's all age dependent. And so the crime is age dependent, the penalty is age dependent, and it all varies depending on the difference in age and the age of the victim. And so this opens up this whole can of worms again. And it's my uneasiness with the bill, to be honest with you, is not that I don't applaud what we're trying to do here or that I don't think we should move it forward. I'm just saying when we get to the floor with this, if it gets that far, we're gonna have a lot of questions to answer of how this interplays.
Senator Pearson's gonna have a lot of questions to answer.
Yes, yeah, true. Someone's gonna have a lot of questions to answer on how this interplays with our current, sexual assault statutes. And so I'm on and against that amendment. I think there's some way we could do it, but I don't think that's it. Thank you, Mr. Chairman.
Okay,
No. Thank you, Mr. Chairman. I appreciate the discussion. Like I say, all I'm trying to get at is there certainly is a difference between a 24-year-old and a 13-year-old. That's a bad deal. My only concern is this 17 and a half and a 21 and 3/4, that whole thing. That's my only concern, and I'm not opposed to. In fact, I'll withdraw the amendment. If that's okay with the chairman.
that's okay with me. You can do that.
Thank you.
All right, that amendment has been withdrawn. I spent all that time penciling it in on my paper. Any other amendments? Is anyone interested in the, go ahead.
Mr. Chairman, I wonder if we're better off doing what Senator Crago mentioned. We just put one penalty in there as a felony, make it one. That would seem less problematic than having multiples in there. That the meshing of this with our current laws is really the biggest problem, is is this gonna mesh or not? I think that's the biggest problem I have with this bill. But so much for the, I think it'd be simpler if we just had one classification for the penalty as a felony with a maximum let to the judge's discretion. That certainly has to be less dangerous than mixing in more. But I look forward to Senator Crago's thoughts.
Senator Crago?
Yeah, Mr. Chairman, I don't have the answer sitting right here. I mean, I think, we can continue to work it moving forward. The other issue is, we're creating a registration requirement, right? So especially we're talking about, if we go back to the 17 to 21 and a half year old example, which I think is the bad spot, I'm gonna call it the bad spot. That person will have to register, and they will be on the, they can get off the registry in 10 years, but I believe, and I'm gonna talk to the good law enforcement folks and Ms. Chambers from the division afterwards, but I think they could have sexual relations and it's totally legal, but if they do this, they're gonna end up on a registry for 10 years, and that's the problem I see. I think we're gonna have to fix that moving forward too, if we can.
Any other discussion or amendments? Is anyone interested in the amendment to subsection G on page 7?
I would move that amendment for subsection G.
Seems like I would probably place it in a different spot. I wouldn't put it at the end of the sentence. I would put it after program. So it's sex education curriculum or program, comma. And it's not really including because it's a different type of program. So I would probably say comma as well as an academic program intended to protect children from predators. How does that?
That sounds
that
exactly
sound
what
good?
I would have said if I would have said it.
Okay. Any discussion on this amendment? Pierre? Yeah, paragraph, so page 7, line 8, after program, insert comma, as well as an academic program intended to protect children from predators, comma. All right, that satisfies that. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposed? All right. Here, let's do a roll call vote on House Bill 189.
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks left an absentee vote of aye. Senator Cole,
Aye.
Chairman Olson.
Aye.
5 ayes do pass with amendments.
All right, thank you. We are adjourned.